Before we begin our program today, we want to start with a moment of silence for Justice Ginsburg. Justice Ginsburg was a jurist of historic stature. She was a champion for many important issues throughout her career, and she became a cultural icon. She did so with intellect and grace that gained respect, even from those with a different ideology. And so let us pause for a moment of silence in memory of Justice Ginsburg. Okay, thank you. My name is Chris Ritchie, and on behalf of Huntington Bank, I want to welcome you to the 4th Annual Class Action Money and Ethics Conference. We had planned to hold this program in person in New York, but due to COVID, we moved this to a virtual event. As a result, many more of you are able to participate. Last year, we had about 100 participants, and this year we have almost 500 attendees. These web-based programs make it easier to receive quality CLE content. And we spent months preparing for this 3-day program, so we hope you find the material interesting. Now let me introduce our conference co-chair, Jeff Clank, Director at Berkeley Research Group.
Thank you, Chris. For those of you who may have attended the conference last year in New York City, you may recall my closing remarks where I noted that, in my mind at least, the real value of this conference relative to all other class action conferences is that it has neither a plaintiff nor defendant specific focus. So many of the class action conferences I attend get branded as either a plaintiff class action conference or as a defendant class action conference. But in the 4 years that Berkeley Research Group and Huntington Bank have been planning this conference, we have really endeavored to draw from a diverse set of opinions reflecting both sides of the V. Chris and I, along with my colleague at BRG, Robin Cantor, have tirelessly worked to make sure that all opposing viewpoints get heard in this conference. And I am confident that this year will be no different, that each panel that we put forward will have a fair and balanced representation of the differing viewpoints that one might have. Particularly as we are entering this political season that proves to be among the most rancorous in recent memory, I think the real value of this conference is reminding us that in spite of our different beliefs, in spite of our differing opinions, we can still find common ground with each other and treat each other with dignity and respect. And in that regard, I am reminded of the friendship between the late Justices Antonin Scalia and Ruth Bader Ginsburg. For those of you who might have access to the Washington Post, there is a touching tribute this weekend written by Eugene Scalia, the son of the late Justice Scalia. And he wrote about his father's friendship with Justice Ginsburg and how, despite their profound ideological and legal differences, they could still treat each other with the utmost dignity and respect. And so if this conference can serve as just one opportunity for us to cultivate ties on the other side of the aisle or on the other side of the V, then I am confident that Chris, Robin, and I will view this conference as a success. And in fact, I think today's speaker is a good example of someone who is thinking outside the box and is really trying to adopt opinions that are common sense. And so with that, Chris, let me turn it back over to you.
Thanks, Jeff. Next, we want to thank our presenting sponsor, the Beard Group, and our supporting sponsors, Alert Communications, Broadridge, CPT Group, Dundon Advisors, Pacer Monitor, and Top Class Actions. Now, this 3-day conference is being recorded. It will be available to view for anyone who misses it. We will post video links on our website, classactionconference.com. Our program will continue over the next 3 days, Monday, Tuesday, and Wednesday, from 11 a.m. to 2 p.m. Eastern Time. So we hope you will join us for the full conference. Now, it is my pleasure to introduce our keynote speaker, Brian Fitzpatrick, Professor of Law at Vanderbilt. For those of you who haven't heard Brian speak, you're in for a real treat. Brian is provocative and entertaining. He is the author of The Conservative Case for Class Actions, which he will discuss today. The book is available on Amazon if you don't already have it. Now, before joining Vanderbilt, Brian graduated first in his class at Harvard Law School, and he served as a law clerk for the US Supreme Court to Justice Scalia. And as Jeff pointed out, Justice Scalia and Justice Ginsburg became famous friends despite their ideological differences. So we've also asked Brian to share his thoughts today about the legacy of RBG. Brian?
Thank you, Chris, and thank you, Jeff. It is a real honor to be the keynote speaker today. I am going to talk about my book, The Conservative Case for Class Actions. I know some of you have already read the book, and so in an effort not to bore you, at the end I'm going to talk about some new material that you may not have heard before, and that is some of the responses that I've received as I've been going around the country to talk about the book. I've received some interesting feedback, and I want to share some of that with those of you who are on the call today. Before I get into my book, though, I do want to spend a few moments to talk about Justice Ginsburg. She was a very close friend to the justice who I clerked for, Antonin Scalia. I did not know Justice Ginsburg well, but I did have the pleasure of several interactions with her when I was a law clerk for Justice Scalia. And I remember her as a very classy person. She invited all of the Scalia clerks my term to come to her office and join her for tea. And it was a really interesting discussion and a really special time to be able to spend with such a special person. As many of you probably know, Justice Ginsburg was famous for being a very bad cook. And so the tea cake that she served us that day was made, she told us, by her husband, Marty Ginsburg, who did all of the cooking in the house. One of the things that we, the Scalia clerks, asked her during our tea with her was how it could be that she and Justice Scalia were such good friends, because not only are they ideological opposites, but frankly, they are opposites in their personality as well. Justice Scalia was very boisterous, and Justice Ginsburg was very quiet. And it just was a real odd couple. And so we asked her, how is it that Justice Scalia is your closest friend on the court? And she told us that the reason she was such good friends with Justice Scalia is because he was only the second person she'd met in her life who could make her laugh. The first person was her husband, Marty, and she married him. And the second person was Justice Scalia. Those of you that have seen some of the RBG movies may know that Justice Ginsburg did not laugh very much back at home, so much so that her kids kept a journal growing up entitled When Mom Laughed, because it didn't happen very often. So the fact that Justice Scalia could make her laugh so much is really what kept them close. They were very, very good friends. Justice Ginsburg was a real pioneer in terms of establishing equal rights for women in this country, as I think we all know. She's a real Thurgood Marshall when it comes to equal rights for women. And I think that will be her most lasting legacy. She was a very careful Supreme Court justice. She did not have as sharp as elbows as Justice Scalia did. So some of her opinions are not quite as memorable as his are. But I think if you look beneath the barbs, you will find very careful legal analysis. She was known for working very closely with her law clerks to make sure everything was perfect in her opinion. She worked very, very long hours, longer than her law clerks, which was rare for Supreme Court justices. So the nation's going to miss her. Those of us who knew her are going to miss her. But, you know, she accomplished more than all but very few people get to accomplish in their life. So she lived a long and wonderful life, and the country's better off for it. And so RIP, RBG. Let me continue, if I may, to talk a little bit now about my book, The Conservative Case for Class Actions. And I really tried to take a deep dive in this book into conservative principles. So I'm going to be talking about a lot of conservative luminaries in the course of this discussion, including this first one I have up here on the board, Milton Friedman. And before I get into Milton Friedman, I just want to tell a very brief story about why I decided to write this book. I decided to write this book about 10 years ago. Yes, that's how long it takes, unfortunately, to write books. I decided I want to write this book about 10 years ago when I read a brief that was filed in the United States Supreme Court. The brief was filed by the United States Chamber of Commerce, a friend of the conservative movement. And the Chamber wrote this brief in a case that I bet many of you are familiar with, named AT&T v. Concepcion. The AT&T case was about arbitration clauses. And in particular, it was about an arbitration clause that had what we call a class action waiver. The clause said that if you have any dispute with AT&T, then you must go to arbitration and you must go by yourself. You're not allowed to join in with other people. It has to be you against AT&T in the arbitration. No class actions, no joinders, one-on-one arbitration. Well, in this AT&T case at the Supreme Court, the question was, is that arbitration clause enforceable if state law says it's unconscionable? And the Supreme Court decided 5-4. My old boss, Justice Scalia, wrote the majority opinion. Justice Ginsburg was in dissent. The Supreme Court decided 5-4 that the class action waivers in the arbitration clauses are enforceable. Now, one of the big questions that was before the court is what would happen to all of the people that had disputes with AT&T that were small dollar disputes. The one in Concepcion was a $29 dispute, $30 dispute. And the question was, what's going to happen with all the people that AT&T allegedly cheats out of $30? If they have to go to arbitration by themselves, they're not going to do it because it's not worth anyone's time to go to a proceeding for $30. And so there was concern at the Supreme Court that these class action waivers are what we call exculpatory. It didn't just move the dispute from court to arbitration, that it in fact would insulate companies from any accountability for causing small harms. So this is when the U.S. Chamber of Commerce got involved in the case, and they filed an amicus brief to the United States Supreme Court. And they said, Supreme Court, do not worry about the little people. Do not worry about the small dollar harms. There is a solution. If the class action goes away and people won't have enough at stake to go to arbitration on their own, there's another solution. The U.S. Chamber said there's a better way to hold companies accountable. And what did the United States Chamber of Commerce say was the best way to hold companies accountable? The Chamber said federal regulators. Federal regulators was the way to hold companies accountable. Now, I was a law clerk to Justice Scalia. I've been a Republican my entire life. I've been a member of the Federalist Society my entire adult life. I've been to a lot of these right-wing meetings over the years. And I've never heard anyone say at any of those meetings that federal regulators were the solutions to any problems. And so when I read that brief from the United States Chamber of Commerce, I said to myself, this is not the conservative way to regulate the marketplace. And I want to try to figure out what the conservative way is. And that's why I wrote this book. And that's why I have Milton Friedman up here first, because Milton Friedman over and over and over again made this point in his writings. The free enterprise system is not going to be saved by big businesses. A lot of times what big corporations that make up the US Chamber, a lot of times what's good for them is good for conservative principles. But sometimes, as Milton Friedman reminded us, what's good for big companies is not good for conservative principles. Big companies have their own agenda. And sometimes it doesn't line up with our conservative principles. There's lots of examples of this. Federalism, for example. Decentralizing power and sharing some power with states is a cornerstone of good government policy from a conservative perspective. The United States Chamber of Commerce is happy to override federalism and get regulations from Washington that preempt state laws that they don't like. So there's a lot of divergence between what's good for big companies and what's good for conservative principles. And one of the things I'm going to argue today is that one of those places where there's a divergence is with regard to class actions. I think the most conservative way to police our marketplaces is not federal regulators. I think it is class action lawyers, and I'm going to explain why I think that. Let me begin with another very famous conservative luminary, Friedrich Hayek. Now, Friedrich Hayek is more of a libertarian than he was a conservative. Milton Friedman, I think, qualifies as a conservative. Friedrich Hayek was more of a libertarian. He's associated with the Austrian School of Economics. So Friedrich Hayek is even more small government, if you will, than Milton Friedman was. This is someone that wanted even less regulation than the Chicago School conservatives like Milton Friedman. But even Friedrich Hayek would say things like this in his work. An effective competitive system, meaning an effective market, needs intelligently designed legal rules as much as any other system. I put this up just to remind us that even conservatives believe that our marketplaces need some legal rules and some policing of those legal rules. Even though conservatives are sometimes caricatured as laissez-faire, we don't want any intervention in the market. That caricature is not accurate. Markets need rules to survive and thrive. And if even Friedrich Hayek, the father of the Austrian School of Economics, the libertarian, thinks we need legal rules in our marketplaces, then all conservatives think that. And that's why I put this slide up. Now, to say that we need legal rules in the market does not necessarily mean we need lots of legal rules in the market. And one of the things I do in the book is I try to distill what legal rules in the marketplace do conservatives and libertarians agree that we need. And I basically come up with 3 rules. Conservatives and libertarians believe at the very least, we need rules that say you can't breach contracts. They say at the very least, we need rules that say you cannot commit fraud. And they say at the very least, we need rules that say you cannot engage in horizontal price fixing. This is the conservative core of the legal framework that needs to be in place to make sure our markets survive and thrive. Now, a lot of conservatives would add rules on top of that, but I think there's agreement among libertarians and conservatives that we at least need those three. And so the question is not so much, are we going to regulate our markets? The question is, how are we going to regulate our markets? Everyone agrees we need at least those rules. And then the question is, how are we going to enforce those rules? And I basically think there are four choices on how we might enforce the necessary rules that everyone agrees we need in the marketplace. And I've put the four choices up here on the screen for you. Little boxes, 1, 2, 3, and 4. And the boxes, the grid, the axes on the grid are both divided into government and private enforcement on one axis, and then the other axis has something called ex ante, ex post. These are Latin phrases for before and after. So we can police our markets. We can enforce these rules either beforehand, before the company acts, or we can enforce these rules after the company acts. We can enforce these rules with the government, or we can enforce these rules with the private sector. And those are, I think, the four design choices on how we enforce the necessary market rules. And let me just give you an example of what one of these boxes means. So box 1 is the government enforces the rules before a company does something. So let me give you an example of this. The most famous example is the Food and Drug Administration. Before you sell, you market a pharmaceutical, you have to get the government's stamp of approval. You have to get the government's permission to do it. In the United States of America, we don't utilize these ex ante approaches very often. We instead use the ex post approaches, which I'm going to discuss. Ex ante is much more popular in Europe. In Europe, you have to get government certifications for lots and lots of things. We could do that here too. We could say before a company offers a new version of its contract with consumers, a government has to sign off on the contract. We could say before a company decides to fire someone, the government has to approve the firing. We could do more ex ante if we wanted to. But if you ask conservatives, if you go into the literature and ask conservatives what the best way to police the marketplace is, they all agree that ex ante is not it. Anything ex ante is bad. And the reason is because it stifles innovation. If you have to get the government's permission to do something before you do it, the lack of foresight on the part of a government bureaucrat is often going to stifle things that could have produced wonderful fruits for society. And so conservatives say the better way to police the marketplace is not to ask for permission before you do something, but to let you do what you want to do, and if you cause harm, to make you pay for the harm after the fact. Ex post is the way we get a vibrant, innovative economy. So the ex post options, boxes 2 and 4, are the best. Let companies do what they want to do, and then if they cause problems, make them pay for it at the end. And hopefully if you make them pay for it at the end, they'll be at least somewhat careful at the beginning. So the real options for conservatives is between options 2 and 4. The government comes after companies when they cause harms, or the private bar goes after companies when they cause harms. Private citizens represented by private lawyers. Those are our choices. Government bureaucrats or private citizens represented by private lawyers. Boxes 2 and boxes 4. Now, I think the choice between boxes 2 and 4 is obvious for a conservative. The private bar is better than the government. The private attorney general is better than the public attorney general. And the reason is because of this conservative theory called privatization. Ever since Margaret Thatcher and Ronald Reagan, conservatives have wanted to privatize pretty much everything. And I think that this privatization theory carries over to the enforcement of the market rules. And what I do in the book is I distill 6 reasons that conservatives want to privatize things. These are the 6 reasons that conservatives over the years have favored private roads to public roads, private trash collectors to public trash collectors, et cetera, private schools to public schools, et cetera, et cetera, et cetera. Some of the reasons are ideological. Given a choice between a smaller government and a bigger government, we like smaller government. It means less taxes. It means fewer bureaucrats looking around for things to do. We prefer to rely on self-help rather than create dependence upon the government. Okay, those are some ideological reasons why we like to privatize, but there's also some very utilitarian reasons why we like to privatize. We think that the private sector has better incentives than the government does because of the profit motive. Government bureaucrat makes the same salary every day, whether they do good or don't do good. In the private sector, if you're not doing good, you're not making any money. You have an incentive to do good. Better resources. The government's always strapped for cash. The private sector can raise money to accomplish anything profitable. There's a bank. There's someone that's willing to lend you money if you can turn a profit. More independence. This is a big reason why conservatives like to privatize. The government is biased in favor of political considerations, like who gave who campaign contributions, what special interest group supported you in the last election, the revolving door of personnel in and out of government. It's what scholars call agency capture, and it's what a lot you hear in the newspapers conservatives call crony capitalism, where one company, one industry will have a lot of sway over an agency and therefore use the agency to its own advantage against competitors. And less centralization. We prefer, again, to decentralize power because we think that that leads to better outcomes, more experimentation, not having all of our eggs in one basket. Diversity will lead to a better overall outcome. These are the reasons we want to privatize everything else. And I argue in the book, each of these reasons applies with equal force to using private lawyers to go after companies when they do wrong, as opposed to government lawyers. Private lawyers means smaller government, fewer government lawyers we have to hire. Private lawyers means self-help, private citizens asking private lawyers to help them instead of private citizens waiting for the government to bail them out. Better incentives. Private lawyers are profit motivated through contingency fees. And that should give them more fire in the belly to go after wrongdoing than the government. There's actually some empirical evidence for that. It's not just theory. There's a couple of studies I talk about in the book, one involving securities fraud and one involving antitrust, where scholars have compared the securities fraud class action bar and the antitrust class action bar to the federal government, the Securities and Exchange Commission and the DOJ Antitrust Division. And they found in both of these studies that the private bar, class action bar, recovers more money every year from wrongdoers than these government agencies do. Now, one explanation for that is they have a financial incentive to do that. And that's why they can deliver. Better resources. This is also true of enforcement. Private lawyers earning those contingency fees can get financing for the cases, whereas the government, their enforcement budgets are often being cut or otherwise being limited. The government is always strapped for cash. Enforcement's one of the least sexy things in the federal budget every year. And the private sector doesn't have that problem. In fact, there's a whole new world now of private sector financing. I know many of you are aware of third-party litigation financing. And so this is another advantage of the private bar. More independence. This applies here as well. The private bar is focused on earning contingency fees. They don't care who gave to whose campaign. And the government cannot say that. And of course, there's less centralization. When we rely on one agency in Washington to enforce the law, we get a lot more centralization than if we rely on thousands and thousands and thousands of lawyers around the country to do the enforcement for us. And so I think all of the reasons we normally want to privatize line up in favor of privatizing the enforcement of these necessary market rules. And I think that if you buy that the private sector, is better than the government sector when it comes to holding companies accountable for misdeeds, then I think you have to believe in the class action. And the reason comes from another one of these conservative luminaries, Richard Epstein, professor at the University of Chicago, Federalist Society hero, had this to say about the class action. The class action is here to say, and so it should, because if you have small substantive claims, small claims, it's the class action or it's nothing at all. So if we want private enforcement of breach of contract, fraud, antitrust, then when the claims are small, the only way we can get it is with the class action. Now, I know one of our panels at this conference is on these mass arbitrations, and I'm going to be very curious to learn if these mass arbitrations can be as effective as the class action device has been at holding companies accountable for small losses. I'm skeptical. I know there's been a few mass arbitrations, but there haven't been very many. I think they're very hard to pull off, and I don't think they can be a substitute for the class action, but I'm willing to be persuaded otherwise by the panel that we have later on in the conference. Now, a lot of people, when I get to this point in the presentation, they say, Professor Fitzpatrick, all of this stuff about privatization, that assumed the good that we were trying to produce was a positive thing. Trash collection, roads, pencils for the schools, what have you. All those things are good things, and we want more of those things, not less. And so we want the incentives of the private sector to produce those types of things. But isn't litigation different, people often say? Isn't litigation a bad thing? If we're suing each other, isn't that bad? And why do we want the most effective suer? Why do we want the people that are best at suing when suing is really not a good thing for our society? Well, to people who have that view, I would just introduce them to two conservative Nobel Prize winning economists from the University of Chicago, Gary Becker and George Stigler. They wrote about this many years ago, and they said litigation is not a bad thing. It's just like trash collection. This is what they said. The view of enforcement and litigation as wasteful is mistaken. They are as important as the harm they seek to prevent. If we don't want fraud, if we don't want breach of contract, if we don't want horizontal price fixing, then the litigation to stop it is not bad, it is good. And we do want to produce the right amount of it. And we do, Gary Becker and George Stigler thought, want to incentivize the private bar because they will get us the right amount, not the government bureaucrats with their warped motives and their limited resources. Now, what does our friends at the United States Chamber of Commerce have to say about this? Well, they raise three principal arguments against the class action. And I devote one chapter in my book to each of these arguments. And so I'm just going to go over them briefly in the time we have here today. But this is what the chamber has to say. The chamber doesn't disagree so much on the theory that private enforcement could be better. They argue the devil is in the details. And the class action details have a lot of devils in them, is what they say. And this is what their three main points are. Number one, they say that the class action system is overrun with meritless cases. And it is a drag on corporate America to have to waste all this money defending all of these meritless cases. In chapter 6 in the book, I dive into this claim and I conclude that the chamber's claim of meritlessness itself is meritless. And I do it principally by looking at statistics on how often class action cases are dismissed on a motion to dismiss. For those of you who are litigators, you know that after the Supreme Court decided this case called Twombly and a follow-up case called Iqbal, a decade or so ago now, 15 years ago now, it has never been easier in American history to dismiss a meritless case. Never easier in American history. If a judge thinks your case is not plausible, he can dismiss it or she can dismiss it right away before discovery. So a small minority of class action cases are dismissed on the motion to dismiss. And I think that means only a small minority of class action cases are meritless. Because motions to dismiss are cheap to file. Companies are filing them. And if very few cases are actually dismissed as implausible, then I really doubt we are drowning in meritless cases. And to confirm that point, one of the things I do in this chapter is I go to the United States Chamber of Commerce's own lists of the 10 most meritless cases every year. They publish their top 10 most meritless cases every year list. I went and examined the 5 most recent years of these lists. And I looked for the class action cases, and there were about 10 class action cases in 5 years on the chamber's list. And I looked at these 10 cases. This is the worst of the worst, according to the chamber. And what I found was there were a couple of cases that were clearly meritless. So one of the cases on there we've all heard of is the Subway footlong case. Some of the Subway sandwiches were only 11 inches. And there was a class action filed about this. This was a stupid case because the bread is the exact same in every single Subway sandwich. It's just that sometimes it bakes a little bit differently and it's a little wider than it is longer, but they all have the same bread. This is a stupid case, and the chamber says, look, our system is drowning in meritless cases. The Subway footlong is not our typical class action case. And if you look at the chamber's own list, you see there's a lot of other cases on there that I think are at least debatable. So there was a case, for example, against Starbucks, where Starbucks was not paying the workers for the last few minutes of every shift. They would clock out and then they would close up the store. And it was like 4 or 5 minutes a night that people weren't getting compensated for. That doesn't sound like a lot of time, but if you add up 4 or 5 minutes over the course of a year, it's about 17 hours, half a work week. That is serious money. That case seemed like at least debatable about whether there was any merit to it. There's another case on the list against the College Board. They messed up the SAT exam. and they didn't want to refund people's money. They gave some people more time on one section than others. It was a mistake. They admitted the mistake. They didn't want to give people their money back. They just wanted to throw out that section of the exam and score you based on the other sections. And people said, no, we want our money back. We like that section, and we're not going to be happy just having our score calculated on the other sections. This did not strike me as a particularly frivolous case. The SAT people messed up. There's another case on the Chamber's list against, I think it was MasterCard, one of the big credit card companies. They ran a promotion that said, if you use your MasterCard, we're going to give X% to charity. Use your MasterCard, X% goes to charity. We've all seen this. Well, what happened was they kept running that promotion all year, even though there was a cap on the amount that we're going to give to charity, and they hit the cap in month 3 or 4. So for the next several months, they kept running the promotion saying, use your card, we're going to give some to charity. And at that point, nothing more was going to charity. Again, I'm not saying any of these are winners, but I am saying that they're at least debatable. And my point here is this: if the Chamber can't find more than 10 clearly meritless cases over a 5-year period, then I don't think we have much of a meritless case problem in our system. If this is the worst of the worst, and half of them are at least debatable, I don't think we have a meritless problem in our system. I talk about that in chapter 6 in the book. This is another thing the Chamber likes to say: the class action lawyers are getting all the money, no one else gets anything. In chapter 7 of the book, I talk about this argument. I've done empirical studies of class action settlements where I've added up every dollar that defendants pay out in class action settlements, and I've compared it to every dollar that courts award class action lawyers as fees in those same cases. And the percentage of the money that defendants pay out that goes to the lawyers is 15%, 15%. That is less than the normal contingency fee by a fair margin. I don't think 15% is everything. I don't even think it's probably enough. I've got a lot of arguments in the book where I say if we were good law and economics conservatives, we'd probably pay class action lawyers more. So the data just does not support this claim. Now, it is true that there are lots of class actions where a small percentage of class members will get any relief from the settlement. The average claims rate in a consumer settlement, according to the Federal Trade Commission, who did a great study on this last year, is 9%. That means only 9% of class members are getting recoveries from a typical consumer settlement. That doesn't mean the other 91% of the money is going to the lawyers. We split the money up among the 9%, or we give some of the money to charity if we think the 9% are going to get too much if we split it among them. The leftover money is not going to the lawyers. So the Chamber's arguments about the lawyers getting it all are just not correct. But I do think it's fair to note that we don't do a great job on getting money to class members in some class action settlements, but I'm optimistic about the future in this regard because technology is making it easier and easier and easier to distribute money to class members. Now you don't even have to mail in a claim. You can do it online with PayPal and Venmo and Cash App. It's going to be easier and easier just to automatically send money to people without any action required at all. And so I'm optimistic about the future of distributing money to class members. But I will say honestly, I'm not troubled by the fact that claims rates in class action settlements are low. As long as the defendant doesn't get the money back, if it goes to charity, goes to the lawyers, I don't care who it goes to. As long as it goes to someone, then defendants are being deterred from wrongdoing. This, to me, is the most important justification for the class action, is to give companies an incentive on the front end not to harm people on the back end. And the way we do that is through deterrence. Well, the chamber has something to say about that as well. The chamber says deterrence is all theory. There's no empirical evidence that class actions deter. And I tackle this in chapter 8 in the book. Some people think that's the best chapter of the book. It's assigned in a lot of law school classes. And what I show in chapter 8 is not only is deterrence a theory, but it's, number one, a conservative theory. It comes out of the law and economics movement. And number two, there is, in fact, empirical evidence to support the theory. It makes perfect sense. If you make someone pay on the back end, they're going to be more careful on the front end. There's one study from antitrust, there's 4 studies from securities fraud, and they all said the same thing. As class action threat goes up, corporate wrongdoing goes down. And so there is evidence for the theory. So I don't think the chamber's arguments hold much water. Now, the last chapter of the book, I offer some of my own thoughts on how the class action can be improved. Just because I think the class action is the best way to police the marketplace, and just because I think our class action system is basically working, doesn't mean it can't be improved. And I have a number of different proposals. I'm not going to talk about them here, but I have a number of different proposals on how we might improve our class action system. I style the last chapter as something of a grand bargain, where I'm hoping that if we tweak the class action in certain ways, Republicans will say, okay, I can live with that class action, and they'll be willing to undo this AT&T Concepcion decision, which basically said these class action waivers are enforceable. And as these class action waivers proliferate through the economy, we're going to have fewer and fewer class actions and fewer ways to privately hold companies accountable. And my hope is that if we can fix the legitimate problems with the class action, and there are some legitimate criticisms when I talk about them in this last chapter, if we fix those, then maybe we can get a grand bargain between the left and the right to keep the class action around for the next generation of consumers and shareholders and employees. Now, I'm going to talk just a few more minutes about some of the most compelling challenges that I've heard from audiences since I started going around and talking about this book. But I'm going to save a few minutes at the end for any questions that you may have. So feel free to chat some questions, and I'll have the moderator read them out to me, and I'm happy to answer them. So we'll have some time for questions if you have any. But let me just spend a couple of minutes talking about 2 good challenges that I have heard to what I argue in my book. Most of the things that critics have said about the book, I think, are answered in the book. So, you know, the US Chamber has an essay criticizing the book. They published it in National Review. And most of the criticisms they raise are answered in the book. And so I just thought to myself, if you'd read the book, you'd actually know what the answers are to those things. But there have been a couple of arguments that have been made to me that have given me some pause. And I want to share those serious challenges with you today. So, number one, I've had people tell me that I have an ivory tower view of how the motion to dismiss works. And in fact, it's much harder to dismiss meritless cases than I let on in the book. And here's why. I've been told that class action lawyers can prevent their cases from being dismissed on a motion to dismiss by alleging facts that they don't know whether they're true or not in the complaint. They can make up facts. They can be cavalier about including facts they don't have much of a basis for. And if you have compelling factual allegations in the complaint, you're not going to be able to get the complaint dismissed without discovery. You can allege something plausible, even if you don't know it's true. Even if you don't really have a basis to think it is true, you can still allege it. And then here we have to go to discovery, and that's going to cost the company a lot of money, and the company is going to settle the case rather than pay a lot of money to go through discovery. So, I mean, this does concern me, I'll be honest with you, because if you can just make up plausible allegations and thereby survive a motion to dismiss, then the motion to dismiss is not a very good device to choke off meritless cases. Now, we have another device that's supposed to stop that. It's called Rule 11. You're not supposed to put allegations in your complaint unless you have a reasonable basis to believe that they're true. And if lawyers are not following that, they should be sanctioned. But I am told that judges are very, very, very reluctant to ever award Rule 11 sanctions against the other side. And so I need to look into this further. This is going to be an area of future study for me. Why are Rule 11 sanctions not stopping this practice from going on if it is in fact going on? So this has given me some pause, and it's given me a future research project. The other challenge that I have to say is a good challenge to the book is that all of the data that I focus on in the book about attorneys' fees and meritless cases and what have you, the data is overall. It's the entire class action system. And I show in the book the system as a whole is working well. But critics have said the overall data that I rely on masks where the source of most of the problems in the system are: consumer cases. Consumer cases are all the ones on the Chamber's top 10 list. Consumer cases, some people say, are ones where if people don't file claims, the leftover money does go back to the defendant. And in those cases, there's no deterrence because the defendant gets the money back. And in those cases, the lawyers really are getting all of the money because very few people file claims and the leftover money goes back to the defendant. So the only money paid out really ends up going to the attorneys. Now, I don't have good enough data right now just on consumer cases to fully refute some of these challenges that center on consumer cases. But I am updating my empirical study as we speak. I'm going to have many, many, many more years of data. And I am looking carefully at the consumer cases to see what happens in those cases to the settlements, what happens to those claims that are filed in consumer cases, to find out whether there's a special problem in consumer cases that we don't have in, say, securities fraud or antitrust or employment and labor cases. So those are the two things that I've heard that have given me some pause and that I want to work on in the future. But the rest of the book, I think, is held together pretty well, but that's before I hear any questions that you may have. I may have to add some more challenges on here if you have some good questions too. So let me pause right there and ask the moderators if we have any questions that I might be able to respond to.
Yes, we've got two questions. One is from the chat. Question, what amount do you consider a small substantial claim?
Okay, this is a good question. And I think the best way to define what's a small claim is an amount of money that's not big enough for you to pursue it on your own. And, you know, that is actually, I think, for most people, a substantial amount of money. If a claim is worth less than $10,000, maybe $20,000, it could be hard to find a lawyer willing to take that case for you because the contingency fee is not going to cover much time and effort. So I think it's certainly easy to say less than $1,000 is a small claim, but I could see arguments that maybe $5,000, $10,000, maybe $20,000 should count as small claims as well. It kind of just depends upon how much time it's going to take to litigate the claim, and therefore whether a lawyer is going to be willing to take it. And so that's not a precise answer, but I hope it gives you some way to define that idea.
Next question is, given the lack of federal privacy legislation in the US and the important democratic small d principles inherent in protecting individual privacy, what are your thoughts about the difficulty in bringing class action cases to enforce information privacy rights? And how should we manage corporate behavior when financial damages may be limited?
So this is actually a great question. And there are a lot of data breach cases and other privacy cases that are working their way through the court system as we speak. Some of these cases are based on statutes, statutory damages cases. Some of them are based on common law principles. You know, I'm a fan of the common law. I'm not, a fan of waiting for the legislature to act. We have common law principles that are old and venerable that I hope we can use to meet some of these new challenges. But even more problematic than finding substantive law to use as the basis of the class action, the bigger problem is the one you allude to in your question. What do we do if there's no concrete injury? A lot of these cases are being stopped for lack of standing, because just because someone has your data doesn't mean that they've done anything bad to you yet. And so this is an issue. In federal court, it's an issue. You have to have a concrete and particularized injury. It has to be some imminent injury. It can't just be some hypothetical future injury. And so this has been a challenge for the federal courts to work through. How do you show an injury that will give you a basis to do something against a company that has let your data out or is otherwise misusing your data? One solution to that is to go to state court, where we don't have the same standing rules that they do have in federal court. Another solution is to be more creative about your allegations on what constitutes the injury to the class members. I've often said that if class members are spending any time to deal with the data breach problem, if they're losing any sleep at night because of a data breach problem, then that's an injury, and that ought to be cognizable in federal court. And so I think there are ways to work around it, but I agree it's a problem that you have to show an injury before you can get in the door. And then there's another problem of relief. If there's been no injury, then what's the right remedy? And I think for a long time in the US, the remedy has been we give everyone free credit monitoring. And we're getting to a situation now where there's been so many data breaches, people have had so many free credit monitorings given to them that that remedy is not useful anymore because everyone already has free credit monitoring. So we're going to have to come up with other ideas to hold companies accountable. Now, I'm just going to end on this point. Just because I think the private bar is usually better than the government at holding companies accountable doesn't mean the government has no role to play at all. The government can do things the private bar can't do. They can pursue criminal prosecutions. The private bar can't do that. There are going to be situations where the money is not good enough for the private bar to go after a company. Those are the situations where the government needs to step up its own enforcement power. We may be getting to a place with privacy and data where the standing problems, the remedy problems are too great for the private bar to take on this accountability enforcement device. And it may fall then to the government to use its tools to hold companies accountable when they do things incorrectly.